Hi, I'm Amy Hsiao, your personal family lawyer, and I have something very important for you today. If you have any form of retirement account, and if you care about how this asset will get passed on to your loved ones with the best tax income results, meaning they'll pay the least income taxes, and in a way that protects what you've worked so hard for from any lawsuit, creditors, or future divorce. If you expect to have more than $100,000 left in your retirement account at the time of your death, even if you anticipate your death to be way off in the future, take 5 minutes to listen to this right now and schedule a private family wealth planning session with us so that we can explore the options of how you can best handle that account. So here's why I'm coming to you today. The Setting Every Community Up for Retirement Enhancement Act, the SECURE Act, was signed into law on December 20th, 2019 and went into effect on January 1st, 2020. It is the most impactful legislation that affects retirement accounts in decades. If your estate plan already distributes your retirement account to your heirs through a trust, you should schedule a time to meet with me to review that trust at your earliest convenience. If you worked with another lawyer to create a trust, should you go back to that lawyer? I'll answer that in a few minutes. First though, if your estate plan does not already distribute your retirement asset to your heirs through a trust, definitely schedule a family wealth planning session with me so that we can explore the options of how best to distribute that asset to your heirs with the least amount of income tax due and the most amount of asset protection in place. Okay, let's look at the SECURE Act as a whole, as it does bring some simple, straightforward, beneficial changes. First, it delays the age for required minimum distributions from retirement accounts from 70.5 to 72 years of age for distributions required to be made after December 31st, 2019. Second, it repeals the maximum age for contributing to traditional IRAs, allowing you to keep contributing to an IRA if you are still working or your spouse is still working over age 70.5. This is good because we're typically working longer as our longevity increases, and so we may want to keep contributing to our retirement accounts so to get that tax-free growth. The SECURE Act offsets these beneficial changes by requiring less favorable distribution requirements for most beneficiaries, meaning those people who will be getting the retirement assets after we die. Under the old law, the beneficiaries of your inherited retirement accounts could elect to stretch distributions over their own life expectancy. For example, an 18-year-old beneficiary with a 65-year life expectancy could stretch out the distributions from an inherited retirement account over 65 years. This allowed a beneficiary to minimize the amount withdrawn in any year and allowed for the assets left in the account to continue to grow without being subject to income tax. The SECURE Act, in contrast, requires most designated beneficiaries to withdraw the entire amount within 10 years of the account owner's death. The SECURE Act does provide a few exceptions to this mandatory 10-year withdrawal rule. First, a surviving spouse named as an outright beneficiary of a retirement plan still has the option of rolling over the benefits to his or her own IRA or taking distributions based on his or her own life expectancy. Second, beneficiaries who are less than 10 years younger than you can still take distributions based on the beneficiary's life expectancy. Third, your minor children who have not reached the age of majority don't have to deplete the account until 10 years after they reach the age of majority. But that still would be a much shorter stretch than previously available. Fourth, disabled individuals and chronically ill individuals can take distributions based on their life expectancy. Apart from these exceptions, Opportunities for stretching an IRA over an extended period of time will no longer be available. What this means is that if you want the people who will be receiving your retirement asset to get the benefits of the long-term tax deferral and the asset protection from lawsuits, creditors, and divorce, we must plan for that now. And we can. More on that in a minute. Depending on the value of your retirement account, you may have already addressed that in your will, revocable trust, on how to distribute that asset to your children or your heirs. Or you may have set up a standalone retirement trust to determine the distribution of your retirement account. Your will or revocable living trust may have included a conduit provision. Under the old law, a trustee of a trust that included a conduit provision would only distribute required minimum distributions or RMDs to the trust beneficiaries, allowing the continued stretch based upon their age and life expectancy. A conduit trust protected the account balance, exposing only the RMDs, much smaller amounts, to creditors and divorcing spouses. Under the Secure Act, the shorter 10-year time frame for taking distributions will result in the acceleration of income tax due, possibly causing your beneficiaries to be bumped into a higher income tax bracket, and therefore receiving less of the funds contained in the retirement account than you may have originally anticipated. Additionally, because all funds in your retirement account will need to be withdrawn within 10 years after your death, under the Secure Act, trusts drafted as a conduit trust would cause all retirement assets to be distributed outright to the beneficiary within 10 years, causing the asset protection you may have built into your plan to be lost. If you want to maximize tax deferral and provide asset protection for your retirement accounts, we should discuss the benefits of an accumulation trust. This is an alternative trust structure through which a trustee can distribute whatever amount they choose to the beneficiaries and continue to hold the asset in a protected trust for the beneficiaries. Note, however, that drafting a trust as an accumulation trust has its own drawbacks. Although a trustee is not required to make distributions to beneficiaries and can retain distributions from retirement plans and trust, retained distributions from traditional IRAs would be exposed to compressed income tax rates that apply to trusts. Currently, trusts reach the maximum 37% tax bracket with undistributed taxable income of $12,950. So plans should be made to address taxes if we opt for this option. Here's the bottom line. We can take all of these into consideration and update your plan considering all the ramifications of the Secure Act and talk about how to pass on your retirement assets in the best way possible to your heirs, to your loved ones at the time of your death. But to do that, we need to meet and consider your family dynamics, all your assets, and the impact of the Secure Act on the whole big picture of what will happen to your assets at the time of your death. We do exactly that during our 2-hour family wealth planning session, during which we educate and empower you so that you know you've done the right thing for the people that you love. Normally, we charge $750 for the family wealth planning session, but when you call us, mention the Secure Act and this video and complete some valuable homework before you come in and meet with us, and we will waive the planning session fee for you. You can click the link in the comments to schedule or call our office at 858-386-0998 and ask for Naomi. She'll give you all the details about the family wealth planning session and get you scheduled for our next available time slot. If you have already worked with another lawyer on your plan, and if you're wondering if you should go back to that existing lawyer or work with us, then I'd ask you to consider if your existing lawyer has proactively reached out to you to empower and educate you to make sure your plans are up to date over the years. And if you are confident that that lawyer will be there for your family in the way you would want in times of incapacity and eventual death. If so, then yes, go back to the existing lawyer that you're working with. But if not, I'd recommend you meet with us for a full review of your existing plan. I normally charge a $950 fee for an existing plan review, but if you mention this video and complete some homework in advance, we will go ahead and waive that review fee for you. Simply click the link in the comments to schedule or call 858-386-0998 and ask for Naomi for all the details. Thank you for watching this video.